Good afternoon, everyone. Welcome to the PDI committee meeting. Before we get started, I'm going to have Shannon go over some of our pre-meeting housekeeping reminders.
Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Program Development and Impact Committee. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference. Per Bagley-Keene requirements, all cameras must be kept on for the duration of the meeting. If you are unable to have your camera on, you must indicate a reason for your non-appearance during the meeting. Please be aware of your surroundings behind you. All committee meetings will be recorded and posted to the State Bar website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen, then select enable auto transcription. Thank you.
Thanks, Shannon. I just wanted to flag, we have Ephraim, who's a commissioner in the attendee pool. So if we could promote him, that'd be great. Please.
And I'll just note while we're promoting Ephraim that Judge Yang has been given permission to have his camera off. He's a liaison and a non-voting member. So just so everyone knows. Hi, Ephraim. Okay. Danielle, could you take roll for us?
Yes. Alakani?
Here.
Babcock?
Here.
Campbell? Escobedo?
Here.
Morales? Smith?
Present.
Judge Rossi?
I am here. Thanks.
Great. We have 5 members present, 2 members absent. We do have a quorum. I'll move on to advisors, liaisons, and staff. Judge Yang?
Present.
Great. Selena?
Present.
Sorry, I should do last names. Apologies. Lauren Klein from LAC. Zach Newman from LAC. I think I saw him in the attendee pool. And then Melanie Snyder at Judicial Council.
Present.
Great. And Yoon Kim from Judicial Council. All right, great. And then for State Bar staff, Danielle McRae is here. Shannon Crossley is here. Mara's in the attendee pool. I believe Jennifer's in the attendee pool. Dwan is here. And Chris and Sylvia are also in the attendee pool. Alrighty, so we are done with roll.
Great. Thank you, Danielle. And we promoted Lauren. There's Lauren. Great. Hi, Lauren. Okay, so this is the point in our meeting where we take public comment. I'll note for the record that we received some written public comment, which were shared with all of the commissioners yesterday. I know that you have some folks who are likely to want to make public comment today. So as a quick reminder, we're going to set the time limit for public comment to 3 minutes. Please raise your hand in Zoom and staff will call on folks. I don't know if are we going to have a timer, Danielle, that people can see, or we're just going to let folks know?
Yes, we have a timer.
Okay, great.
Shannon will operate the timer. And is it 2 minutes or 3 minutes? Judge Rossi, did you have a preference?
I'm gonna do 3 because I think that that there's gonna be folks who want to be heard, and I'm afraid that 2 minutes might rush people, and I want to make sure that everyone gets a chance to say what they want us to hear. So I'm gonna say 3, and then I'm gonna ask everyone as a reminder to address their public comments to things that the Trust Fund Commission and PDI actually have jurisdiction over. Just as a quick reminder to everyone. And I don't believe that we had anybody send in a request or a written request. So I think we're just going to do by hands. So Shannon or Danielle, whichever of you would like to call on the first person.
Sure, Shannon, I saw Jennifer Smith had their hand raised first. If you wouldn't mind allowing them to speak.
They are allowed to speak now.
Go ahead, Jennifer.
Hi, thank you. Can you hear me?
Yes.
Wonderful. Thank you so much. My name is Jennifer Smith. I'm the Executive Director of the Legal Aid Foundation of Santa Barbara County. I wanted to speak today in support of the Cal HFA funding recommendation for the San Luis Obispo Legal Assistance Foundation. We are a project partner on the proposal. Thank you for committing to support a largely underserved region of the state. Despite stereotypes, according to a California poverty measure, the Central Coast region has the second highest rate of poverty compared to other regions at 19.3%. We have no ABA accredited law schools in our counties, and nor the presence of large international law firms. My organization has provided foreclosure prevention and related home preservation services since the initial foreclosure crisis, and we're excited to continue our ongoing partnership with San Luis Obispo Legal Assistance Foundation. I also wanted to commend the fact that this funding source uses area median income as its measure. The federal poverty level is increasingly a challenging measure for us to use in our regions because the California minimum wage puts many families and workers over the income qualifications for other sources of funding, and most people in poverty work. Separately, I hope that's something that can be addressed, but for today, we want to support the funding recommendation for San Luis Obispo Legal Assistance Foundation. Thank you so much.
Thank you.
Okay, the next person I see with their hand raised is Hannah Brady.
Hi, yes, good morning. Thank you. I did time myself and I was at 5. I didn't know we had a 3-minute limit, so I'm gonna do my best to get through what I can. My name is Hannah Brady. I'm the executive director of the Senior Advocacy Network, one of the agencies that has not been recommended for funding for this round of Cal HFA. I'm here today to offer the committee a different perspective on the strategic impact of their selections. The scoring rubric linked to this application placed an extremely high emphasis on disaster recovery services, nearly 17%. As a very small organization working under an extremely tight deadline with no grant writing team, I can admit that we may have made a strategic error in not including this work in our application. That decision, however, was thoughtful on our part. We have done disaster recovery work in the past, and we would certainly participate in it when and if our communities were struck. But it felt disingenuous to us to include it as a foundational part of our application. In our communities, disasters are not the greatest threat to home ownership preservation. Our community members are losing their homes because of predatory lending practices, mortgage servicing errors, domestic and international scams, and members of their trusted circle who are taking advantage of them. This is what we've worked on for the last 3 years. At the current recommended levels, our county, Stanislaus County, only stands to see an investment of $83,390 in the next 4 years from these funds, like most of the Central Valley counties. So while I can accept responsibility for a procedural error, I cannot remain silent on the underlying injustice that will exclude the Central Valley again from an expertise that is rare, important, and powerful. These recommendations would not only drain the Central Valley of a rare, complex legal offering, but also diminish one, and actually two, when we include HERA's rejection of the leading entities who are currently and actively building and leading this sector for legal aid by working to create precedential case law and building the bench. with HERA, we are the only two of the last Cal HFA round of grantees that were not awarded. And we have spent the last several years building webs of collaboration, support, and providing services. Our program director was actually pivotal in securing this second round of funding at all, but none of that gained us any points in the application process. So I am here today to ask the committee to reconsider and other things that I don't have time to mention, but I edited as much as humanly possible. Thank you for your time.
Thank you. I didn't know we had playoff music. That's a nice touch. I hadn't heard that before.
Better than
Feels
like a
like the
blaring
Oscars.
alarm. Yeah.
Feels like the
It is a
Oscars or
little bit like
something.
the Oscar. It's nice.
Um,
It's better than an alarm. You're right about that, actually.
the next
Uh,
person I see is Stacy Tutt.
Hello, my name is Stacy Tutt, and I just want to thank you for the opportunity to speak here with you today. I'm a senior attorney with the National Housing Law Project, and I wanted to come to thank you for the funding support that's being provided to our legal services providers in order to help homeowners stay in their homes. The National Housing Law Project serves as a support center for the entire state. So we help support both legal service providers and HUD certified counselors in keeping homeowners in their homes. And this funding is pivotal to ensure that we continue providing those services and that all of our legal service partners are able to do so. I did also want to speak out in support of the applications of both the Senior Advisory Network as well as the Housing and Economic Rights Advocates. The reasons I have singled out these programs in particular is because the recommendations currently do not recommend funding these very important organizations. As the statewide support center for all of the legal services organizations, we know firsthand the importance of the expertise that housing and economic rights advocates provide. In particular, during the time of COVID, we relied heavily on HERA as one of our statewide organizations to provide services in areas that otherwise would be unrepresented in foreclosures. And so their work has been instrumental. Oftentimes I relied on them when we're dealing with very complex cases that we receive from our HUD certified counselors to provide services when other legal service providers were unable to do so. So we also see and recognize their particular expertise in dealing with foreclosures based upon homeowners associations or HOAs and the foreclosures that happen there. And their infrastructure and support of that is highly valuable in all the work that legal service providers are doing across the state. In addition to that, I would also speak out in support of the Senior Advice Network. And the reason we support their application to this is that they are in an area that is significantly underserved in the Central Valley. Also working with our older adults and this very vulnerable population, having a service provider in their geographic location is really key in order to making those connections and providing the support. Also, their lead attorney on this project has been instrumental in helping us advance our entire network's expertise on reverse mortgages and protecting again, older adults who are particularly vulnerable to foreclosure, who've already tapped into the equity of their homes in order to be able to stay there. And so SAN has done a phenomenal job in stepping up into this area and also providing expertise for reverse mortgage borrowers. So again, we greatly appreciate the support. We couldn't continue this work without you, and we need to continue to support the infrastructure that's so necessary to keep our homeowners in their homes. So thank you again for your support and consideration.
Thank you.
Great. And then the last person I see with their hand raised, at least at this time, is Monica Glicken.
Hi, thanks so much for giving us this chance to make comments. Obviously, you had a lot of great applications, and as you know, this is a time of distress for all of our organizations. I did want to point out, I would be remiss if I did not point out that of the organizations you funded, it looks like about 5 million went to organizations serving LA County and only 400,000 to one organization serving Orange County. And wanted to point that out because Orange County is very under-resourced compared to LA County in terms of number of organizations. Yes, we are, even if you look at it in comparison to poverty levels, there are 12.5% living in poverty versus 17.8% in LA County. That translates to there are 22%. Our number of people living in poverty are 22% of those living in LA County, but the funding level was only 8% of what was given to LA. Meaning, if it were proportional, $1 million should have been awarded to Orange County organizations. And that's putting aside the fact that there are much fewer organizations serving low-income people in Orange County, and that politically we do not have the, well, how should you say it, political will of our municipalities in our county to support low-income people. And in fact, low-income and communities of color. In our region, similar to the other person that spoke about Central Valley, predatory lending and fraud schemes that particularly target limited English proficient communities are a key factor, not natural disasters. And unfortunately, with this decision that was made about funding, you had very tough decisions. But just to point out that, yes, that does mean that largely that those communities will not be served in Orange County. Thank you.
Thank you. I don't know if we have other public comment. I see Selena's hand up. I don't.
The only other person that has their hand raised spoke already, and so I don't know if Hannah, if you meant to raise your hand again, or okay, it went away. So yes, just Selena.
Okay.
And I'm happy to wait till all the public comment is gone.
think that's it.
I also looked at this and I hear the people who are giving public comment, and one of the pieces of friction that I heard a lot of during the partnership grant discussion is not enough information about the current grantees, that when you were considering the grantees and applying a scoring rubric, it essentially meant that some organizations would be defunded. And I know we have a rubric, and I know that helps guide conversations, but I think a focus on disaster or a focus on innovation sometimes deprioritizes core funding and core work that's already happening. And so it will lead to layoffs if you don't continue to fund an organization, which is really different than starting a program. And some of these organizations who have the fellows in particular, they'll have to recruit and hire those fellows. And I'm usually someone who talks a lot about pipeline, and I love that we have the fellowship opportunity, but the fellowship funding is pretty significant for this, and dialing back the fellowship funding a little bit would not harm the organizations that are funded that much, but it would allow to be able to fund a couple more organizations, particularly those who currently get CaliHFA. Because right now there's $3 million allocated to fellows, and maybe some of that could be to the organizations that will have to stop the programs that are currently running. So I just wanted to offer that as a suggestion of kind of thinking through. I know you've done a lot of work to score, but we don't know where the next disaster is going to be. And some of these regions that don't have a disaster now, they may be facing the next disaster come January. So that was it.
Thanks, Selena. Is there any other member of the public that wishes to make public comment at this time?
I don't see any other hands raised.
Okay, great. And thank you all of you who made public comment. We greatly appreciate that. All right, moving on to the chair's report. Again, want to welcome everyone. Thank you for being here. We have a very packed agenda today. We're going to be talking about the funding recommendations for the CaliHFA grant, as public comment indicated. We're also going to be talking about recommendations regarding the letter that we worked on for the community justice worker proposal. We also have recommendations regarding the Legal Aid Justice Technology Collaborative work plan, and hopefully we'll also have time to discuss our ongoing post-election thought partnership and convenings, and maybe hopefully even get to our Cypre funding conversation. But we do have a packed agenda for today, and so please help us get through it as best we can. Danielle, a staff report from you?
Sure. I just have a very brief comment to make. Wanted to give a brief reminder that there was interest in potentially making edits to the 2026 partnership grants request for proposal. And if so, that would need to come through the PDI committee as substantive changes to an existing grant RFP. And so we would request up to 2 commissioners that are interested in volunteering to work with staff to discuss potential changes to the RFP that we would then bring to this committee in early 2026 ahead of that RFP release. So you may volunteer now, or if you want to think about it, send an email to me or Dwan, but we would solicit up to 2 volunteers to help with that conversation.
Great. So if there are any commissioners that are interested, please let Dwan and Danielle know. And we will certainly find folks to help you with that. Thanks, Danielle. Anything else we should know about?
Nothing else for a staff report, no.
Okay. Then let's move on to approving the minutes of our August 28th, 2025 meeting. And which were attached to the agenda, so hopefully everyone got a chance to take a look at them. Is there a commissioner who wishes to move for the adoption of those minutes?
Well,
Ken, are you? I see your hand.
yeah,
Are you
I have a comment before I'll make a motion, and that is that there was one item on the agenda for that meeting which we didn't get to because we ran out of time. That was the report concerning the California Legal Aid Interagency Roundtable. And I would ask that we agendize that. That's not on this agenda for this meeting, and we already have a packed agenda for this meeting. I would ask that we include that item on a future agenda of the committee so that we don't lose track of the good work that's going on with the CLARE effort.
Yeah, that's a great suggestion.
And then I would make a motion to approve the minutes.
Thank you. Yes, can we please let's make sure not to lose that because it is really valuable work. And then Ken has moved to adopt the minutes of our August 28th meeting. Is there a commissioner who wishes to make a second?
Second, Efrain.
Thank you, Efrain. And any discussion or changes other than what Ken has already outlined to those minutes? Seeing none. Danielle or Shannon, I'm not sure which. Can we take a roll call vote?
Yes, I will do that. Alikani?
Yes.
Babcock?
Yes.
Campbell? Absent. Escobedo?
Yes.
Morales? Absent. Smith?
Yes.
And Judge Rossi?
Yes.
Okay, 5 yeses, 0 nos, motion carries.
Great. Thank you, everyone. Okay, on to our first item of business, 4.1, which is the approval of the Cal HFA grant funding. And I see that Mara has been promoted. Hi, Mara. If you would like to kick us off,
I can do
that
that.
would be great.
So good afternoon, everyone. Thank you so much for joining us. And I'd like to begin, since I feel like this is less of an unveiling and more of a follow-up, to sincerely thank all those who have submitted both verbal and public comment for consideration during the discussion of the Cal HFA funding recommendations. I'm going to give a brief overview of this grant, the scoring process, and then the funding recommendations before turning it over for discussion. So as a reminder, I know this information was presented to the committee before. The Cal HFA grant is a 2025-2029 grant with $2,080,000 dedicated for awards, with up to $1.9 million for State Bar administrative support costs. The grant period will begin December 1st. However, grantees may charge qualified services back to July 1 of this year, and the grant will extend through June 30th of 2029. The focus of the grant is to preserve home ownership, protect home equity, and prevent homeowner displacement through foreclosure prevention, loan modification assistance, litigation against mortgage service violations, debt collection defense, and related consumer protection services. Clients living at or below 150% of area median income are eligible for services under this grant.
The funding preferences for this grant, which were negotiated with Cal HFA, included serving clients who either are experiencing natural disaster and or have experienced natural disasters affecting their home ownership, and a focus on serving underserved communities. Organizations who plan to develop these expertise were also given funding preferences during the scoring process. We received 36 applications from 35 organizations proposing services across the state. The total request for grant funding was nearly 79 million. And I remind you, we had approximately 22 million to allocate. 66 million was dedicated to fund projects, and approximately 12 million was specifically to fund fellowships that support these projects. So essentially, these are fellows staffed on the projects for varying lengths of time from 1 year to 2 year. The grant does place a maximum fellowship length of 2 years for recent law graduate fellowships. So requests for fellowship funding was nearly 16% of the requests for funding that we received from applicants. As a quick reminder, this is the project scoring rubric that was used in scoring these applications. The applications were scored across 5 different categories, looking at impact, administration, evaluation of the grant, and then funding preferences, victims of natural disasters, and underserved communities. So taking into account these approaches, the scoring team looked at the applications. The 36 applications proposed projects that would primarily serve Southern California in 21 cases. 9 proposed projects would primarily serve Northern California, and the remaining 6 applications included 4 with statewide proposed projects and 2 that proposed serving counties split equally across Northern and Southern California. So the scoring rubric was taken as a guide and a starting point to evaluate and discuss. High scores do not guarantee funding, and the Commission does maintain discretion in its funding decisions. There were a total of 85 points possible, so 60 points went towards the project description portion of the rubric, and 25 points went towards funding preferences. The scores were reported as attachment 3 to the memo, or sorry, attachment C, also attachment 3, to the memo, and included both the raw scores and percentage of the total points possible. In terms of the overall approach to the fellowships, funding eligibility for fellowships depended on applicants' proposed projects scoring at least meets expectations for impact administration and evaluation. Funding requirements included that the application have a comprehensive, meaningful strategy for recruitment and selection of qualified fellows, integration into the legal work and the project, and career development and professional growth in legal aid. Meeting these requirements does not guarantee funding for fellowships. And again, the Commission maintains discretion in the funding decisions. So with that preamble, these were the funding recommendations, as I am sure you have all seen in the attachment to the memo. The approach funds applicant requests at a lower percentage than other State Bar competitive grants, but it does allow for the Cal HFA grant to fund and support QLSP services across 56 of the counties, and increase opportunities for both regularly and provisionally licensed attorneys to start their careers in housing legal aid. This approach would fund 15 of the proposals that are particularly strong, 14 QLSPs providing services, and a support center which would act as a resource across the whole state. And these funding recommendations, as I mentioned, are included in attachment C and are also highlighted in table 2 of the memo. Of the 15 applicants, the scoring team recommends project funding. 13 requested funding for law graduate fellowships, and all but 1 met the requirements that the scoring team was looking for funding fellowships. So there would be 33 FTE fellows, which equates to roughly 16 two-year fellowships because each of the FTEs are 1 year and the fellowships are capped at 2-year lengths. So with that overview, I'd like to move on to discussion and humbly cede the floor so that we can further discuss these funding recommendations.
Thanks, Mara. Before we start our discussion, I just want to thank again State Bar staff, my fellow Commissioner Aaron Smith, who helped score. We spent a lot of time together, probably, I don't know, 20 hours together talking and probably another 20 hours reading. This was a huge undertaking for State Bar staff and for the PDI committee. And so I just want to thank everyone before we start our discussion for all of your hard work and thoughtful consideration. And I don't know, Mara, if I missed it in your presentation, but we did also add at Aaron's request from our August 28th meeting, the additional 5-point special consideration, which was specifically intended, if I remember correctly, and Aaron, please correct me if I don't, really meant to ensure that we hit as many of the counties in California, as many of the communities that we could. And so we did an extra 5 points under that special consideration. And we did approve that at our last meeting in August.
That is correct.
Thank
you, Judge
okay.
Rosie. Yes.
And I perhaps I missed it in your slide deck, but I just wanted to remind everyone that we had done that. And it was a great recommendation from Aaron at our last meeting. I know that Aaron and I are obviously here. We scored. We were a part of this. We've been part of all the conversations about the Cal HFA funding. But I want to open it up to any of our other commissioners who want to who have questions or want to talk about it, because Aaron and I are here, and so is Mara to do that. And everyone is okay. There's Ken. No one wants to raise their hand. Thank you, Ken.
Okay. So a couple of different thoughts. And I appreciate all the work that both you, Judge Rossi, and Aaron, as well as State Bar staff, put into the scoring process. And one thing that occurred to me in listening to some of the public comments, and it also occurred to me as I was reading through the written comment that we received yesterday concerning the Cal HFA proposal, is that we have in front of us your conclusions concerning scoring. And it's very easy to look at the scoring rubric and see that you decided to fund the higher scoring ones and not the lower scoring ones. That's pretty clear. And I'm not suggesting that we ought to be looking at the entirety of the applications. That's the job of those of you who scored. But because we don't see the applications, we're left a little bit in the dark on some things that I think might be helpful in understanding how scores were arrived at. For example, the issue of partners in applications is something that we really have no idea about given the information presented to us. And yet one of the people who spoke this morning or earlier today and in the written comment, it was clear that there are programs that have collaborative partners. And some of those collaborative partners are QLSPs. Well, we have no idea who those are, so we have no idea what areas are being covered because all we see is who the applicant is and not who their partners are. And it might be helpful in the future for us to also know, because we'd get a better idea then of what's, if nothing else, what the geographic area that's being covered, besides just looking at a list of counties, which is what was included in the materials right now. So you would have, say, in addition to having a list of like the 1 or 2 or 56 counties that a particular applicant is covering, you might also have a list of who their collaborative partners are, because that might help us in having a better understanding of how the scoring worked. Number one. Number two, I do think Selena's point that she raised earlier today was well taken. I do think that you could still support the pipeline initiatives, which are extremely important, and take another look at some of the programs that scored close to the cutoff and maybe address some of the issues that were raised in some of the public comments.
Thanks, Ken. Can I ask a follow-up question to your comment? Because I hear what you're saying about partnering, and I just wanted to ask a question about that, if that's okay.
Sure.
So, Aaron, also, you feel free to jump in if you, but some of the applications, and I can't remember the exact number off the top of my head, a handful of the applications mentioned that they were going to partner with another organization and actually were going to subgrant some of their money to those organizations, whereas others mentioned, I don't want to say anecdotally because that's not really right, but some of them mentioned in their application, we will reach out and partner with this organization in an informal or formal setting. And so I want to be responsive to your comment about partnering. Are you wanting sort of both groups to be included in a sort of next time around?
I think the former. I think really only the ones where there was an indication of a planned subgrant arrangement where there was something more formal as opposed to the general, yeah, we plan on talking to people in our area.
Okay, great. That's really helpful. And there were a handful of organizations, like I said, who said they were going to subgrant some of their funding. But I wanted to just make sure that I understood what you were saying.
Judge Rosie, I might just jump in. I think there might have been a third group, since we're fleshing this out, of proposals where there's not a subgrant. They each applied for their own, but the program is described as a formal partnership, if that makes sense. So more than just, yeah, we work together and we'll continue to do so, but also not a subgrant, if that makes sense. So just to clarify, and your follow-up question, Judge Rosie, was helpful to clarify Ken's comment. Thank you, Ken.
Yes. And I think that's something we can do, right? Juan or Mara, that's something that we can do next, if, in a subsequent.
Yeah, I'll just say we can do that, and because the scoring team, I wasn't part of the scoring team, but I know that they had a spreadsheet and they organized themselves, so it was part of that. But if that's something that's helpful for the committee moving forward, we can add that to that. The other thing I want to note is you do all have access to Smart Simple, and you can go in them yourself and look at grant applications, even if you're not scoring. If you're unfamiliar with how to do that, then we can get a staff to meet with you and train you up. But everybody has a Smart Simple account, and you have access to all of our grant applications.
Oh, I did not know that.
Mm-hmm.
Did other commissioners know that, and I just didn't know that? Okay.
I did not know that.
That's exciting information. Thanks, Juan. I didn't know that. I mean, I'm not promising to go in there when I'm not on the scoring team, but that is really helpful information. So thank you. Are there any other commissioners who want to speak before I talk about where I think we should move forward next and some steps that we've already taken? Okay, so we've heard some of the public comment, and we did take, consider some of this before today's meeting, because we were trying to be responsive, and really the scoring team spent a lot of time focusing on making sure that we could cover as much as of the state that we could cover. And I think we hit maybe all but one county, or maybe we got all 57 now. I can't remember. But there's two. And we spent a lot of time talking about how to distribute the money. And I can't remember whose comment it was. It might have been Monica Glicken's comment about funding how much money was going to each place. So we did discuss coming up with and came up with what we think is a revised list of grantees. I don't know if we have that available, Mara, to show people.
We do have that.
Okay.
But do you all want to talk about the
Well,
reasoning
yeah,
before we
so we
flash?
have, right. So we have a revised list of grantees that the scoring team has considered and talked about. But because we revised this list, what that means is that the funding allocation has to be rethought again. And so what I think I would like to do with the committee's approval is show the list, the revised list, which does add 2 additional, right, Aaron? 2 additional grantees to the list. But what that does mean for the rest of the committee is that that the scoring team has to come back along with State Bar staff and rethink how we allocate the money, because we spent all 22,000 or 22,000, all 22,080,000 when we came up with the first list. So if we fund 2 additional grantees, which we would like to do, that means that we're going to have to rethink the money. And that's something that we can do right here in this moment. So Mara, if you have the revised list,
Can I
and
just
you
jump
could,
in real
yes,
quick,
please.
Josie, before we show that? And I wanted to thank everyone for the public comment, which we listened very closely to, and really appreciate you coming and sharing your very helpful perspectives. And a lot of your points are very well taken. And as Judge Rosie said, when we were looking at the approving the rubric for this grant, the RFP, it was very important to us to make sure that built in to the RFP was some way to make sure we could cover the state. We're a big state, very diverse state, a lot of different regions, a lot of different counties. And we did add those special consideration points specifically for that. As a part of the scoring team, my experience with that tactic is that it was largely successful. I wish it could have been like maybe even more successful, but through those special consideration points, we were able to fund the far north, the Eastern Sierra, and the Central Coast, which are quite, under-resourced areas of the state. As Mara said, our initial recommendation reached 56 out of 58 of the counties, which is so close. But we did miss 2. And so I think, reflecting on the comments and thinking about it further, as Judge Rosie said, we want to reach them all, right? And look and make sure that all the regions, including the underserved regions, are receiving what we can possibly do, right? 22 million is never going to be enough for this state, but to do what we can. So with that said, can show the revised list maybe.
Thanks, Aaron.
Are you pulling that up, or do you need me to? Yes to which?
You're muted, Mara, so it was hard to tell which you were saying yes to.
Okay, she's doing it.
You're muted though, Mara, just so you know, you're muted.
Yeah. Okay. I suspect there's a lot of tabs open.
Are you able to see the list now?
Not the
Yes.
full list. It's at least partial for me.
The
It doesn't.
last one I see is Neighborhood Legal Services.
I think, could you call out the 2 names of the organizations that you're
Sure.
pulling in
So-
and maybe describe why?
Yeah.
So the list would add to the original 15 Central California Legal Services and Housing and Economic Rights Advocates.
That's great. And the last one I can see on my screen is San Luis Obispo. So I don't know if that,
Yeah, it's
I'm not-
sorted alphabetically.
okay, okay.
Yeah.
Great. So as Mara indicated, and as Aaron said, we went back and really tried to meaningfully address the concerns and wanting to make sure that Central California was covered, and also to add HERA back into the fold, both for their work as a QLSP, but also for the work they do supporting foreclosure work for the rest of the QLSPs that are here in California. So what I would like to propose to the PDI committee is that based on the public comment and the rethinking that the scoring team has done before today's meeting, that the PDI committee approve the list of grantees as it is now on the screen. So adding in to the original list, Central California Legal Services and Housing and Economic Rights Advocates. That we approve this list of grantees, and that the scoring team be sent back to redistribute funding, given that we have added 2 new grantees into this mix. By doing that, just so that the PDI committee understands, we would be approving the list of grantees, but then the scoring team would go back and do the funding again to try and do all the things that we talked about the first time, making sure that money is distributed throughout the state in meaningful ways, and also fellowships. But that won't allow PDI committee itself to approve the actual funding amounts before it goes to the full commission meeting on November 7th, because we don't have another meeting scheduled. So what that would mean is that the first time the PDI committee would see the actual funding amounts and have a chance to talk about it as a committee and not as a whole would be at the November 7th full trust fund commission meeting, when we would ask the full trust fund commission to approve the funding itself, and not the list of grantees, well, the list of grantees and the funding. But and Afreen, I see your hand.
Yes, thanks, Just Rosie. First, just want to say that I really appreciate the responsiveness and the fact that we're a commission that takes into consideration the comments from those closest to the ground, and we try to accommodate. So love that. I'm just wondering in what you're proposing as far as how the way our approval would play out, if staff or scores have any sense of what might be the approach for reallocating the dollars. Is it a straight, take from everyone's amount, or is there going to be other type of subjective criteria, equity focus? Just curious about it. I trust the process because it usually lands in something really solid, but I'd be curious to know as we consider approving it.
Yeah. And Duan, did you want to respond to that, or did you want me to?
Yeah, I was gonna, but if you want to first, but I was gonna
No. Go
maybe
ahead.
let
You
everybody
first,
know
and
what
then
the
if
staff is doing behind the scenes. So as you see in the kind of the original recommendation, the scoring team took more of a little bit of a formulaic approach to how they did cuts. I think it was in and Judge Rossi and Aaron can speak a little bit more to this. I think they thought that approach might be a more equitable approach. I think we're gonna pivot a little bit more now that we're having 2 in the mix, and given everybody's comments, again, the public comments about distribution of funding, we're gonna take a slightly approach that's more consistent with some of our other grants, where we're gonna look at the scoring team did look at the budgets, but we're going to take a little closer look at budgets and then do an analysis of to see like which projects are new, if there's new staff hired, outcomes, distributions in regions. So we're going to take a little bit more of a comprehensive approach. And so the cuts are not going to be a formulaic approach. When they come to you at the commission, they are going to look a lot differently. So we're not going to say, for instance, now we're going to fund 2 organizations and they need to be funded, say, at $1 million, and then just do a straight up like formula approach. That's not going to happen. So what's going to happen now at this stage, which State Bar staff has already started to do, and I'm going to be supervising this myself, is we're going to take a first stab at doing that initial analysis. Then we'll meet with Judge Rossi and Aaron next week to go over that approach. And at that point, they will give us some strategic direction, and then they will guide us to kind of a final number. But we're going to take the bulk of that as a first step. And then obviously the scoring team will meet at least once next week. If we need to meet another time, then we will. And then again, like Judge Rossi said, those recommendations will go directly to the commission, the funding piece of it. In the memo itself, it'll say that the committee approved the slate of these 17 organizations, but that funding recommendation itself is coming from the scoring team.
Thank you. That's very helpful.
Yeah, and I'll just add that's exactly what what we contemplated, and I think and I think that's we're trying to be responsive in a ways that sort of does exactly what you mentioned before, Selena, about where are we going to do this and how are we going to do this, and should we rethink fellowship money to versus direct service and that kind of stuff. So we're going to try and take a less formulaic approach the second time around because we have to. We can't, and it doesn't make sense to do it a formulaic way the second time around. So, Erin, anything to add to that? That's your understanding as well, correct?
Yeah, that's nothing to add on that. I maybe just wanted to add, if it wasn't clear, if people aren't familiar with the 2 organizations that we're proposing to add to the list. I mean, Central California Legal Services name gives away that they're in the Central Valley, and Mariposa County was one of the counties that was not in our original 56. So we did think about that, obviously, and are recommending further funding in that region of the state. And Housing and Economic Rights Advocates operate statewide in all of the counties. So we just, in trying to cover the state, that was a, really strong consideration for us.
Yeah. Thanks, Erin. Okay, so Dwan, I'm allowed to make a motion, right?
Yeah, and I think Efrain has his hand up. I don't know, Efrain, is there?
Well, I wasn't sure if it was still up.
No, still okay. Maybe
It's an old hand, as they say.
Okay.
All right. And before I do that, though, I want to make sure that there aren't any other commissioners who want to make comment on this or be heard on it or have questions or concerns, because we are here to respond to those if there are. Dwan, your hand is the only hand I see.
Yeah, I'm sorry. Can I just make one more comment? And I see Ken too. This was like this funding stream was oversubscribed by 3 times. I think Mara made that point. I do want to emphasize, I haven't seen this kind of level of competitiveness in a grant in a long time. And it's kind of it's not surprising because of the moment in time that we're in. We do plan to keep CalFHA apprised of this and see if there's any opportunity fairly soon, if there may be another distribution or if there's additional funding available. And we will communicate that the need is just so high and our programs are overstretched in every way. And so, hopefully there could be another tranche coming, but we'll work with them to see if that's a possibility.
Thanks, Dwan. All right, Ken, and then Jacqueline.
Yeah, as part of the additional review that staff is engaged in, that's sort of more of a, I don't know, qualitative than quantitative, for lack of a better way to describe it, type analysis. I would go back to the public comment from Monica Glicken. And I think that it's one of the things that we ought to be looking at is the extent to which organizations are working in an environment that is supportive of the client community we serve versus those that are in an environment that's hostile to the client community that we serve. And having spent the last close to 25 years of my legal career in Orange County, I can tell you that Orange County is particularly hostile to low-income people, particularly low-income tenants. And that's very different than situations, say, in Los Angeles County. And I'm not suggesting that any of the programs in Los Angeles County not be funded. They're all well-run programs. I suspect their proposals were extremely well put together. But the reality is that tenants face a different reality in Los Angeles County than they do in Orange County. That's just the political reality of where people live. And I think that kind of reality ought to be considered when reviewing competitive grant applications like this.
Thanks, Ken. Appreciate that comment. Jacqueline.
Yes. So first of all, I just want to thank all the staff members and all of the commissioner reviewers for all of this, all the work that's been done. An incredible amount of time was spent on this, and I think we have very good selection of applicants to fund. And what it's really amazing the amount of um, applications that we received, and we have such a limited amount of money. So I think we're doing the best that we can and getting a equitable, somewhat equitable spread across the state in the face of all of the need that is out there and the growing need. So important. So I'm in agreement with everything that's been said. It's been a really good and thorough discussion, very thoughtful. So I appreciate that, and I'm in agreement.
Thanks, Jacqueline. I appreciate that.
Judge Rosie, I believe
Yes.
Mara has resolution language she can pull up that is
Oh,
based on
that
the
would be
conversation that you all just had, but then of course is
Oh.
hoping to edits
Thank you,
as a
Mara,
starting
for being
place. So.
super responsive and drafting language while we were all
No problem. It's a starting place. So let me pull up that slide for you really quick.
Well, we have great wordsmithing folks on this committee. Aaron and Ken and Efreen and Jacqueline. So I'm sure that if wordsmithing needs to be done, we don't have shy folks on here who won't make any suggestions.
Perfect. And I am going to share the screen in such a way that I can edit in real time rather than it filling my entire screen. So I apologize if you see the slides to the side. But I'll make it as large as possible.
Thank you. Great.
So as revised, the resolution reads, resolved that the Legal Services Trust Fund Commission Program Development and Impact Committee recommends the list of 17 applicants as revised and presented during the committee meeting on October 24th, 2025, and that the Legal Services Trust Fund Commission approve funding recommendations for these applicants per 2025-2029 CalHFA grant. Further resolved that the PDI committee recommends that the Legal Services Trust Fund Commission delegate authority to state bar staff to review and approve the CalHFA grant budgets. Oh, sorry, Dwan, you're suddenly muted.
You got muted.
I was going to say, I'm not sure if it's just my screen, but we only see your partial of, I don't see the whole motion, but maybe it's just my screen.
Okay.
If everybody else is seeing it, then maybe it's just me.
Yeah, I can see it. Dwan, you know what
it
it is? Just try double clicking on the image and see what, because that's what it was doing for me.
Oh yeah, that works now. Thank you.
Okay.
Got it.
And just to flag, the further resolved language there was also in the memo, and that's just because of the time constraint. We plan to ask the commission to delegate authority to state bar staff to review and approve the budgets, but those budgets would of course be based on the funding amounts approved by the commission.
Thanks, Danielle. Appreciate that. Okay, any wordsmithing that we need to do? Any questions about? Everyone's okay with this language?
Sorry, at this point, you're not explicitly making recommendations on funding yet, because that funding hasn't been
That is
determined, right?
Yeah,
correct.
that's what I was
Correct.
gonna.
And yeah, we're not a, we are approving the list of 17 applicants. And basically, uh, basically the funding recommendations won't be approved by the PDI committee itself before it goes to the full trust fund commission. So the commissioners who were on the PDI committee, of course, will be at the can be at the trust fund commission, will be at the trust fund commission full meeting in November, when the actual funding recommendations for each of the 17 applicants would be approved.
I think,
that would require,
should we strike that, that then? And
Yeah.
yeah, I think that's maybe what Raul was saying is like, do we need that in there?
No,
Yeah.
I think we can't, because that then.
I will defer to council on.
Yeah, maybe some indication that the recommendations will be provided by staff about the actual funding amounts.
Or the scoring team.
Well, the
Yeah,
scoring
sorry,
team, yeah.
Yeah.
I feel like we have a Frankenstein resolution now. So
Yeah, no, that's terrible.
Yeah.
We have to,
so it says we recommend.
Yeah.
But, like recommend what, like the list, but to
Well-
whom and to do what? So like, is the committee recommending that the full
Yeah, I
commission
think-
approves the list in the future?
Mhm.
Yeah, I was gonna pick up on that and say, are we saying PDI committee approves the list of 17 applicants
think we
as
need to say
revised,
that-
blah, blah, blah.
I think that we do need to, can we say that? I mean, we're approving the list of 17. The committee approved, and then we recommend that the full, that
Well-
the scoring team.
Yeah, you're missing. Yeah, it's resolved. The legal PDI committee recommends that that the Legal Services Trust Fund Commission approve the 17 applicants, as you know, and then onward. I don't think you.
Oh, I see what you're
I
saying.
think the Frankenstein. I don't think we need to deal with the funding piece of that, right? Because we've talked about that, Raul. Unless you want a separate resolve saying that.
Maybe we should have a separate resolved about the funding part then.
Yes, yeah, that it's both approving funding allocation
because I
for
wanna
the
make-
final grant budgets, yeah.
Right, and because I want to make sure that we have that part in there that so that, you know, it's clear that the PDI committee, you know, recommends the 17 and that the PDI committee, that the scoring team is going to bring the funding to the whole trust fund commission. Whoa.
So the first one should say recommends that the commission approve the list of 17.
Right,
Okay.
Yeah, I think that's
We
right.
add that. Okay.
yes.
Is it helpful or too wordy for the first further resolved to say they will be presented to the LSTFC at their November 7th meeting, or does that feel unnecessary to folks?
I don't think that's necessary, Danielle. We don't do that
Okay.
for other. It's
Great.
It's fine.
Yep, that's fine.
Okay. Less Frankenstein-y, more clear. Okay. Any other wordsmithing that we want to do? Okay, not seeing any. Do we need a motion on this, Dwan, or do we just take a roll call on?
We need a motion and we need a roll call vote. Please.
Okay.
A motion and a second, please.
Yes, a motion, second, roll call.
I will move approval of the 3 resolutions on the screen.
Thank you.
And I'll second.
Everyone seconding.
We had a couple. Judge Rossi, I defer to you on which one to take there.
I heard them talking on top of each other, so I'll let Ken and Kathleen
Ken,
decide.
yeah,
Which
Ken can second. Ken will
Okay.
carry
Great.
this.
I
is
have-
gonna defer to Ken.
I have Aaron Smith making the resolution and Ken Babcock seconding. I'll now take roll call vote. Alakani,
Yes.
Babcock,
Yes.
Campbell, absent. Escobedo,
Yes.
Morales, absent. Smith,
Yes.
and Judge Rossi.
Yes.
5 yeses, 0 nos, 2 absent. Motion passes.
Great. Thank you all. And thank you, fellow commissioners and liaisons for being so engaged in this. I appreciate the robust discussion and all the public comment that we received. Okay, moving on in our agenda to another heavy hitter for State Bar staff work. Item 4.2, which is the letter, the approval of the recommendation regarding the letter to the community justice worker proposal. And do I see, there's Jennifer. Hi, Jennifer.
Hi, I'll share my screen if that's okay.
Great. That'd be great.
All right. It's in presentation mode. Okay. My name is Jennifer Zelnick. I'm a principal program analyst in the Office of Access and Inclusion, and I, along with the working group, will be presenting agenda item 4.2. The working group was Judge Rosie, Aaron Smith, and Judge Yang. And really grateful for all of their support on this important topic. For our agenda, we'll review some background about the CJW proposal, then the working group will present its recommendations. After that, we'll have time for a discussion, and finally, we'll review the proposed resolution. All right, so let's go over some background. We know from the State Bar's 2024 California Justice Gap Study that our state is experiencing a pervasive and growing access to justice crisis. And unfortunately, this is a national problem as well. In 1963, Gideon v. Wainwright enshrined the right to counsel for individuals facing criminal charges. However, to date, the United States does not guarantee a right to representation or really any legal help for civil matters. As a result, people who cannot afford an attorney either represent themselves or choose not to pursue legal recourse. And self-represented litigants, as well as those who do not engage with the legal system, have worse outcomes than those who have legal representation. Unfortunately, due to shifts in the legal market and ongoing difficulties with recruitment and retention in legal aid, there are simply not enough attorneys for low-income and underserved Californians. One way that some jurisdictions, such as Alaska, Arizona, and others, have expanded access to justice is through community justice workers, or CJWs. Data from these jurisdictions demonstrates that CJWs provide effective limited scope legal services. Clients report very high levels of satisfaction, and the public is not harmed by these services. In California, some IOLTA grantees already rely on justice workers to support their work. Thus, a statewide program could help the Commission scale up legal services that grantees already identify as valuable, safe, and necessary. In December of 2024, a group of grantees, as well as LAC and others, published a proposal to establish a statewide CJW program to do just that, provide limited legal services to low-income Californians under attorney supervision. So we'll briefly review the draft of the CJW proposal, noting that the authors have shared written public comment with the committee yesterday, which highlights some changes they intend to make to the final version of their proposal. The proposal recommends that grantees, as well as legal service organizations who are not funded by IOLTA, would apply to the Commission for authorization to operate CJW programs. However, as the public comment from the authors indicated, the revised proposal will include only IOLTA grantees. The proposal suggests that the Legal Services Trust Fund Commission would serve as the authorizing body for legal services organizations. In this capacity, the Commission would ensure that applicants met program requirements, which you can see on this slide, include things like a training plan for CJWs, ensuring informed consent for participating clients, plans to protect the security of client files, and proof of malpractice insurance that covers CJWs. The Commission would also be tasked to notify the State Bar when it authorizes LSOs to host CJWs. And the proposal also recommends an external evaluator review the program after 5 years. However, the authors shared in their public comment that the revised proposal updated this recommendation to allow a little bit of flexibility to have an evaluation between years 3 and 5. The proposal contemplates distinct roles for the Commission and the State Bar. The State Bar's proposed role would include maintaining rosters of authorized LSOs and CJWs, developing a process for authorized LSOs to certify CJWs to the State Bar, communicating the rosters of LSOs and CJWs to relevant authorities, including those who enforce the unauthorized practice of law, and reporting annually to the legislature and the Supreme Court all complaints received against CJWs. So as you'll recall, in June, the PDI committee formed a working group to provide written feedback to the proposal authors. The working group met 4 times and communicated very extensively about this proposal and is excited to present its recommendations today. While I will ask the working group members to present about specific recommendations, overall, as you saw in the posted materials, the working group recommends that the PDI committee and the Commission support the authors' efforts to establish a statewide CJW program. The working group also wants to thank the authors for providing written public comment, which I've referenced a bit already. With that, I'll turn things over to Judge Rosie for more on the working group's recommendations.
Thanks, Jennifer. And again, thank you to the State Bar staff and my fellow commissioners who served on this committee. We did meet a number of times and talked quite a bit and exchanged emails and lots of really great thoughts. And so I want to again thank State Bar staff, commissioners, and of course the authors of the CJW proposal. So as many of you hopefully saw in the letter itself, and as Jennifer just alluded to, the committee, the working group, I should say, had 8 major suggestions. They were outlined in the memo, and I'll go over a few. We're gonna all sort of present on this because we all spent quite a bit of time on it and all felt really strongly about being able to speak to the committee about it. But as Jennifer said, overall, we do support establishing a statewide CJW program, especially to help shrink the justice gap for low-income, rural, and underserved Californians. So if we can go, thank you. Look at that. You're like reading my mind. So the first comment, suggestion that we had was about the foreground consumer protection and lack of public harm. The proposal, we think the proposal would be strengthened and would be and really benefit from a more direct conversation about consumer protection. We noted that the authors cite studies in the footnote in the appendix, but we really think that argument should be brought to the forefront. We know now, good or bad, that non-lawyer help is not monolithic. Folks are looking to lots of different resources these days to get their legal help. And we want to make sure that the fact that there that there's a lack of public harm is something that is put out in the forefront, so that whether it's the legislature or the Supreme Court or someone else who's reading this really understands that the public is out there looking for legal help in lots of ways, and that the public would be better served with a program like this. So that was the first point that we really wanted to make, was not to bury that lead, but to really put it out there in the front. The second thing that we wanted to talk about, and we thought was important, was this idea of quality control standards. The idea of supporting consumer protection, which is obviously one of the something that's at the forefront for the state bar, and was something that was a big concern for committee members. We want that to be perhaps more standardized. We suggest implementing quality controls to support that consumer protection. We suggested minimum standardized training and supervision criteria. We suggested just off the top, and sort of told the state bar we thought it would be great if the state bar could create some sort of foundational mandatory training modules that could cover things like ethics or competency, other relevant rules. And one of the reasons why we wanted to do this was, first, for quality control purposes, but really it lowers an administrative burden for all of these organizations that might want CJWs down the line. If there's some standardized training, some standardized resource sharing, that it really does lower that burden for them. And so we thought that it was important. And I think, to the consumer protection piece, it really, if everyone's getting the same training, then there's that level of comfort that everyone has been through the same training. We suggest a minimum of 4 hours. You might have to switch the slides, because no, it stays on this slide. I wasn't sure if the slide wrapped, Jennifer, or okay, great. We are recommending a minimum of 4 hours of legal ethics training prior to certification. And much like the ethics requirements for attorneys, we're also suggesting at least 1 hour of implicit bias or bias reducing training for folks. And again, it speaks to that same piece of public trust, generalized training, so that everyone has at the same training and the same level. Maybe switch to the next one, Jennifer. I know I'm talking fast because I know there's a whole bunch of recommendations, and everyone's got things to add. The third thing we wanted to talk about and highlight was, we think it's important that that there be broad support, and that broad support is demonstrated. One of the concerns that the working group had to do with unions specifically. Many legal aid organizations have their staff unionized, whether it's paraprofessional or the legal aid attorneys themselves. And we wanted to make sure that this was considered. We know that that the unions may have something to say about work going to community justice workers, and so we wanted to make sure that the authors reached out to the bargaining units that were involved, and that they got that buy-in early. I think that strong support from the bargaining units, from the labor unions, would probably help move this proposal through the arenas that it will need to move through. And of course, letters of support. I know that there were a number of organizations that signed on to the initial CJW proposal, but as broad a support as possible, we think would benefit in getting this proposal moved forward. The fourth thing that we wanted to talk about was the program costs and how it's going to be funded. Because the proposal itself doesn't talk about funding, and there is no funding stream attached to the CJW proposal. And so we recommended advocating for a dedicated funding stream for both grantee and non-grantee organizations. Administering a program like this will take funding, and we also noted that the State Bar couldn't administer the CJW program for non-IALTA grantees without a new funding stream. So I think that's something that we were hoping the program authors could consider moving forward. And then Erin, I think you're going to take the next.
Yeah, thank you. So the fifth comment that we wanted to share, kind of in a similar vein as the separate funding, ties into evaluation of the program and also how that would be funded. So we, of course, as the authors suggest as well, want a balanced and rigorous program evaluation. We all share that goal. We discussed at the working group that the Trust Fund Commission's, one of the Commission's existing core responsibilities as a grant administrator and, kind of participant in the CJW program would be evaluation anyway. And so the Commission is going to be evaluating the CJW program as part of these duties anyway. And also, recognizing that the State Bar's Office of Research and Statistics has a significant amount of specialized expertise and staffing support, already funded staffing support. So we do think that recommending that the Office of Research and Statistics to do a program evaluation would help balance that rigorous evaluation with keeping costs low in the absence of a separate funding stream. And then also the initial proposal suggested evaluation at the 5-year mark. We did want to recommend doing that and an earlier evaluation. We're recommending 3. I think the public comment that we got from them said they're open to, we recommended 2. Their public comment said they're already considering 3. So I think they're thinking along these same lines already, the authors. But that will just allow for any necessary earlier course correction and understanding how the program is rolling out and working. Next slide. Thank you. And so maybe I'm losing track. 6th suggestion is that we wanted to recommend that the group work with the Trust Fund Commission and specifically the Rules Committee to actually explore any State Bar rules or statute changes that might be helpful to amend so that this proposal can be as impactful at a statewide level as possible. During our last agenda item, you heard me and a lot of people talk about statewide coverage, underserved areas, rural areas, and attorney deserts. And I personally believe this proposal is one of the most promising I've seen in my career to help truly address those attorney deserts and underserved areas at a statewide level. I was happy to see the authors in their public comments say, we're open to talking about rules changes. So I think that would be great to help both QLSPs and support centers play a meaningful role in rolling out this CJW work and reaching every single county, all 58. So I'll go on. I won't go into the specifics there unless someone has questions of what those rules might be, and there would be a lot more conversation in the future about that. But the 7th proposal, I guess, is just really kind of an administrative one. The proposal was written last December before the 2024 Justice Gap study came out. So a recommendation to just update that citation and the underlying data references to the new report, as well as the 2024 Legal Market Landscape Report.
Is Judge Yang still on?
Yes. wanted to thank Jennifer Zelnick, the State Bar staff, Chair Judge Rossi, and Aaron Smith for all of the work that they did. So we're recommending that the PDI and the commission as a whole support the proposal suggestion that the commission serve as the authorizing body for the program. But what we've concluded is that the proposal is unclear on some of the responsibilities and obligations to effectuate the program. I think it's perhaps better to start with the straightforward and simpler issue, one of which is how will the state bar maintain and communicate the roster of authorized legal services organizations and community justice workers as recommended by the proposal. So the proposal says the state bar is going to maintain the roster of LSOs online, but it's vague about the roster for CJWs. Will the roster for the CJWs also be available publicly online? Will it be searchable by name, by LSO, by the scope of practice? And which section or division of the state bar will maintain the roster? How will the rosters be updated? And to whom will the rosters be communicated? The more difficult and complex issue that needs clarification is whether the CJWs will have to abide by any professional code of conduct and ethics. The authors of the proposal need to clarify who's going to develop that code of conduct and ethics, and what CJW's professional obligations will be. Will it be the same as attorneys? Will there be any professional obligations of the LSOs that are supervising the CJWs? And lastly, we recommend further clarifications on enforcement and regulation of those sort of obligations under presumably a code of conduct or ethics. The proposal recommends creating a reporting system to the legislature and the Supreme Court on all complaints received on CJWs annually. That means the commission is going to have to develop a system to review complaints, but it's unclear, will it be the commission that investigate or some other part of the state bar? The authors are also not clear as to whether CJWs will fall under the jurisdiction of the state bar and or the Supreme Court. And further collaboration is needed to determine whether the state bar is going to investigate and enforce the obligations under that code of professional conduct and ethics. And these clarifications sort of go to the heart of the state bar's obligation to protect the public, as Judge Rossi mentioned in the beginning. And we believe it's helpful to get these clarifications to make the case for the implementation of this proposal. And then we wanted to open it up for questions and discussion.
Thanks, Judge Yang. Thank you, Aaron. Questions from Ken? Questions from Ken?
Thanks, Judge Rossi. So I want to commend the folks that worked on the comment letter to the authors of the study for their extremely thorough analysis and deep dive that you all took into this. It's very, very, very much appreciated. I did have a couple of very specific comments on the letter. And some of that is guided by the response that you got back from the authors in response to their preview of the letter. One is to comment B concerning standardized training. and the other is to comment D concerning cost. First, as to comment B, in the letter, you make very clear the reasons why standardized training will be important for approval of this program, particularly by the Supreme Court, particularly given the experiences with the paraprofessional program and the Blue Ribbon Commission efforts back years ago. And I think that somewhere in between is really where the sweet spot is in terms of what training ought to look like. I do think that some kind of standardized training is going to be important for the court to get behind this and probably for the legislature to get behind it. But I also think that there are going to be areas where more localized training that's unique to particular jurisdictions is going to be important. For example, the training in landlord tenant will look very different in a rent control jurisdiction than it will in a non-rent control jurisdiction. And so I think we would want to encourage LSOs to engage in that sort of more localized substantive training of their CJWs. But I also think that having some baseline standardized training beyond just ethics and bias, which I think would be very important to have standardized. I think some standardized substantive training is important, while recognizing the also important needs of tailoring things for localities. With respect to comment D, I think, and this may have been intentional, it may not have been, it seems to me there's a muddling of the costs to the state bar and the cost to the LSOs. And that may have been intentional in the drafting of the letter, but it seems to me those are two different cost concerns. You start off at one point talking about the costs that the trust fund commission that is going to bear because of all of the new processes that will have to be engaged in. And then you sort of in the next sentence or two talk about the costs that the LSOs will have to bear by all of this. And I think those are two very different cost considerations, and I would suggest sort of breaking them out and talking about them separately.
Mhm.
Thanks, Ken. Those comments, and thanks for taking the time to read it all through and as well. Selena, I see your hand.
Well, I'm very supportive of this proposal. To Ken's point about the cost, one thing that we've been doing is in the working group is trying to figure out the different costs between the getting it to happen, so getting it to fruition, getting it through the Supreme Court, through the legislature. There's a cost before we even get to an actual program. But then there's phases of cost, assuming we get assuming we get past the finish line. There's kind of like development, implementation, and then there's an ongoing cost. And I do think that the working group members are very open to looking at your thoughts around monitoring and curriculum development. And if we are able to actually get this to fruition, there are a lot of organizations that are very dedicated to collaborating and working together. And I think there'll be pieces that are cheaper than we thought because of the focus on coordination. So a lot of the curriculum development, there's a lot of platforms that organizations are willing to use. And also when one organization develops a training, if it's appropriate to other regions, we will figure out ways to roll it out. So, but there's going to be that first cost is going to be quite high, and then ongoing will be a lot better.
Thanks, Selena. Dwan and then Jacqueline.
Yeah, on the cost piece, because this is something that Jennifer and I have talked at length about. It's a little chicken and the egg piece because I think we can give a little, actually, our office has really done a good job or get a very good sense of a cost analysis. The problem is we need more direction from the working group and also the courts and the legislature in terms of monitoring and what you expect, right? Because we can draw parallels to certain, and we have experience because we've administered federal funding, so we can do kind of the full. I would say the full suite, right, as something like that, or you could do a more leanly monitoring, and we check for less things and do all that. So that's kind of we need a little bit more direction in terms of what's a must. And then from there, I think we could do more, at least for the administration of this on the trust fund commission side, the cost. And because we have a structure already, I think even in terms of building out that foundation, we could do it pretty cheaply. And like you said, there's the building it from the ground, getting it off the ground. And then the other big unknown is how many programs are going to participate. And that I don't know we think it maybe the first couple years is it's going to be a small number, and then hopefully actually that number will increase, and then maybe in that year 3 or 4 it might explode a little bit, and then again once we have a more stable, then the processing of that, the in and outs of programs will be a lot easier, and I think not too time intensive.
Thanks, Storm. Appreciate you guys doing that work as well. Jacqueline.
Yes, this sounds like it's going to be a really great program. I'm really impressed with the work that's been done, really good work from the staff leadership and also the working group. I really like it. And because it's a work in progress, so to speak, there's so many good suggestions. That list is good, and the discussion we've had is very important. A lot of good points. And so I think the evaluation is going to be really, really critical. And I would push for an annual evaluation, because that way, we can, as things are evolving, we can see them early on and be able to make adjustments as we go along. Because I'm also concerned about the cost, the potential cost. We don't have all of that. We don't have all of the pieces yet. So then I think that evaluation, a frequent evaluation, would be really helpful to keep us, on track, going in the right directions.
Thanks, Jacqueline. I think Dwan and Jennifer are both probably going to respond to that.
I was just actually more curious, in like why not a 1 year evaluation? I mean, this is a question for Judge Yang and Aaron, and at least for the first year. I don't know if ongoing we need every year once the program's up and running for 5 or 6 years and it's shown to not have kind of issues, but why not 1 year? And why two that you're when you guys were thinking through the recommendation?
Yeah,
So
Jennifer, do you want to respond to
oh,
that? No, that's a good question. And Jennifer, I don't know if you were going to respond to that.
I wasn't, but I think Judge Yang was going to.
Oh, okay.
we did have a discussion on this, and I want to note that I think the drafters actually proposed a lengthier time of maybe 3 to 5 years, and we said 2 years. My recollection is we struck the 2 years because a year review is kind of, I think there's added costs for the staff to kind of do that, and it's unclear if the data is going to actually reflect or we're going to have enough data to come to a good assessment. But we also wanted less time than what the drafters wanted, because I think it gives reassurance, kind of like what Dwan and others have stated earlier. Why not sort of evaluate early so that if there's any issues that arise, we can address it? And we thought a 2 year kind of struck the right chord in that it would give the legislature a sense of security, but and also balance the cost to the staff, the burden to the staff to do it every year when the data might not even come out useful in the first year.
Well, and I do want to, I guess, quickly kind of respond, because I think if you're doing like a 5 year out evaluation, that might be something that, and I think the authors kind of respond to this in their written response back, like an outside consultant, somebody that's reputable. I mean, like, we did the Justice Gap study, we outsourced some of that. And then, it's still, but then I think we also do in-house evaluation, is I think what Jennifer's referring to RS and what we do in-house. So it doesn't have to be at the year mark, the more extensive, but just a couple touch points so that we know that the program is not is going okay or well, or there's nothing to really like adjust to. Again, we don't have to decide obviously now, but just I think we have the full gamut of options at our fingertips. It doesn't have to be a full out evaluation the way I think maybe the authors are imagining at year 5.
If I can just add on a little bit, I think another something else to keep in mind is that through the annual review process for IOLTA grantees, as well as the triennial monitoring visits. Even if it's not a systematic evaluation of a program, there will be touch points with grantees who are participating in the CJW program annually. So just to add on to what Dwan said, there will be those moments of perhaps slightly less formal evaluation where we can adjust as needed.
Yeah, that sounds right. Erin, did you want to add to any of that, or?
Yeah, I think you all covered the points. Thank you.
Does that sort of help answer your question a little bit, Jacqueline, about the thinking, the working group thinking on that?
Yes. Yes,
Yeah.
that would be fine. It just I think it's important to monitor things, very tightly as
Well, and I think we wanted to make sure that we didn't wait so long that we couldn't course correct if something wasn't going right.
Mhm.
And we needed course correction. We didn't want to wait too long.
Right.
Yeah. Thanks for that comment. I appreciate it. Selena.
Well, I think the evaluation here is really contemplating an entire, the entirety of an evaluation of all the programs participating, the different substantive legal areas, the different types of community justice workers, whether they are, based at another nonprofit or based within their own organization. And as Judge Yang said, I think that's going to be really hard. But I trust that organizations are going to be doing self-evaluations ongoing, collecting data from their clients. In Alaska, it was really clear how much money organizations were able to bring in for their clients served by community justice workers. So I think there'll be ongoing evaluation on a regular basis by the individual programs, but it's going to be really complicated to compare, an organization in Los Angeles County using community justice workers for eviction defense versus an organization in, Fresno County using community justice workers for public benefits. So that's going to be the tricky part, and why they probably anticipated 5 years would need to take that. But I think 2 years or a shorter term period is fine. It's more complicated because of the different models we anticipate.
Thanks, Selena.
Judge Rossi, can I respond to one of Ken's points?
Yes.
Sorry, no, Efreen, let's finish out the evaluation discussion because this is going to pivot us to the training. So yeah, please go ahead.
Go ahead, Efreen.
Sure. Just appreciating the discussion. So this is just off the cuff, but I will say, I think the consideration will be tactically, other than demonstrating the efficacy of it. I do think there should be consideration, and if there is if you do require legislative support and ongoing support as you launch the program, of potentially considering two kinds of evaluations. One is on design and deployment, and what did that look like? And we are up and running, and here's how it got to the right places. And then later, what the community impact is, as you think about what stakeholders you'll have to inform and demonstrate progress, deployment, impact, versus we'll come back to you in several years and tell you that it made a difference. So just a consideration. I'm not too keen into how you would need to sustain this, but I would imagine in something new like this, you will have to say something about deployment, especially if you'll be going back for more dollars.
Thanks, Efreen. Erin, did you want to?
Thanks. Sure. Yeah. And I noticed this as well in the author's public comment back to us. And I am wondering whether our letter needs to be redone to respond to that now, or we're sort of like in a cycle here. But thank you, Ken, for your point on the standardized training. I completely agree with your points that we need to allow for, localized, specialized trainings and the programs to design what's most helpful to their communities. I absolutely agree with that. And with your point, which I hope came through in our letter, that we think setting some standardized, not like substantive area specific, but kind of serving the public kind of trainings, ethics, bias, this kind of thing, the rules. I think that was more of what I had in mind when we were writing. And Judge Rossi and Jennifer, and Judge Yang, I'm only speaking for myself. So if you had a different understanding, please chime in. But when I was thinking of, standardized training, that I was thinking about the latter, setting a floor of ethics, possibly even creating just a set ethics training, and rules, bias, serving the public, that kind of thing. And not mandating content on substantive law, but maybe mandating a floor. Like we expect they will receive, I'm just making up a number here, 2 hours a year of training in the substantive issue area in which they're going to work. And then you figure out what that's going to be and what goes in that training. But we do expect there to be 2 hours of something, so I don't know if that's helpful, and maybe we need to make our letter more clear on this point, or make sure we're all clear about it. That my intent at least was not to say, you must attend training on dissolutions if you're not going to be doing dissolutions. That's a waste of everyone's time. So
No, Jennifer, you may want to chime in, or Judge Yang too, but that was I think we were trying to create a floor, and really to that consumer protection piece of everyone's received the same, ethics, bias, whatever training. That's a floor. Letting the, providers do the rest of the, the substantive training, but really just making sure that everyone had that floor. So if that doesn't come across in our letter, it should. At least that was my understanding.
Mine also.
Yes, mine as well.
Okay. So if our letter doesn't make that clear, we could touch that up, I guess. Efreen and then Jackie.
Sorry, that's an old hand. I
Oh, when you
realize
show old
it's
hand?
lower after I
You're-
comment. Yeah.
You just like to keep that way. We always remember to call on you. Okay, Jacqueline, did you?
Yes. So, one other area that, I'm really interested in is as we evaluate this program, I'd like to really hear from the consumers, from the people being served. I want to get some feedback on what they think about the services they're receiving, what they feel, how they feel they were served, what worked, what didn't work, and get some input from some of the consumers.
Yeah, I think that makes a lot of sense. Yeah, and I think that any sort of evaluation piece should include that. I can't imagine anyone would disagree with that. Everyone's got their hand. Okay, it's like when everyone puts their hand up, the screen moves around. Okay, so Erin put her hand down. So Selena.
because I was trying not to have an old hand, but Selena, please go first. And then
Okay.
To get to Jacqueline's point about consumers and actual users of the services, I'm really interested, and I don't know how we can build this into an eval, but with the State Bar's Justice Gap Study, it's really clear that we don't have enough attorneys to help. That's why community justice workers are so important. But what's really clear in a lot of other surveys, including from American Bar Association, is that people don't go to lawyers even when they know they have a legal problem. And there's a lot of reasons why people don't trust lawyers. They're embarrassed, lots of reasons. And I'm just genuinely curious, would be more willing to go to a community justice worker, and if that would build more trust in lawyers. If the community justice worker says, I work with a lawyer at this legal aid organization, like I can help you on this issue, but if you have other issues, you have to go to them. So I'm really interested in the I guess the good collateral consequences of if this program rolls out.
Yeah, no, I think that would be really interesting to see if there's a way to track that. Like, had you thought about, asking the question, had you thought about going to a lawyer? And, if so, did you yes or no? Did you, if we could track that, that would be really interesting. Good collateral damage. Okay, Erin, did you have?
Yeah, just one last point. And I love that idea, Selena. I just wanted to come back to my theme for the day of statewide coverage in underserved and rural and attorney desert areas of the state. Just to comment that, I noticed in the author's public comment back to us that they're no longer proposing to include non-state bar grantees as possible authorizing agencies. And this was also at the working group, one of the cost-related bumps in the road that we identified was the state bar cannot use existing funding to, authorize or supervise non-grantees. So we were all kind of wondering how that was going to work. It may end up, I mean, I hope there's some way to ultimately include them if separate funding can be found. But it's starting to look like, at least initially, that won't be the case, that we'll have our kind of current pool of grantees. So I just want to underscore then that that's going to make it even more important to really look at that statewide piece, because we're going to be locked into they're all wonderful, all 100 and whatever, 20 of them are wonderful, but it's not going to enable us to expand geographic reach beyond what we have. And we already know we have attorney deserts and underserved regions with our current slate of providers. So it's going to be even more important, I think, to look at rules updates, statute updates, so that we can enable that pool of service providers to reach the underserved areas.
Yeah, it's a good point, Erin. Thanks. Okay. Any other comment from folks about this? I really appreciate how engaged everyone is in this conversation and on this project. And Jennifer, again, if I haven't said this enough, and I know I said it to you privately, thank you for just the tremendous amount of work you did putting all of this together. And I know this is not even the only thing you're doing. So really appreciate that, the work. So I think we have perhaps a resolution. And I guess a motion. Do we have a resolution sort of drafted already to approve the letter? And I don't know if we feel strongly about if we need to tinker with the letter or how we tinker with the letter, but
so this is the resolution that was in the memo. I'm happy to read it if that's helpful, but it doesn't contemplate any changes to the letter, given that the memo was published prior to the feedback, the public written comment.
Yeah.
Yeah, and I mean, realistically, we can't wordsmith a 10-page letter right now. So, I mean, I don't know. I feel like we just need to approve what we wrote, but then we all know, like, this is an evolving situation, and there's already a draft 2 of the proposal. So the letter's already a little out of date, but it is what we had before us at the time. So is that what you want to do, just move forward on that basis?
I mean, I think you're right. That it's an evolving thing, and this is what we wrote in the memo in the letter that we wrote in the memo, and before we got back the comment, the day before we met. So I don't think we can wordsmith all of that right now. So I mean, my recommendation would be that we sort of adopt it, understanding that this working group is not ending its work. And that we intend to stick around and continue to review and evaluate and as the project itself evolves, right? So that would be my recommendation. Ephraim has a comment.
Actually, I'd like to move that we adopt this resolution, understanding that what we're doing is recommending the letter for approval to the full commission. And I'm sure at that juncture, there will be additional perspectives and comments, and we could see what should be done.
Can I interject really quickly before you ask for a second? I can also, if it's helpful, add a short note in the memo to the commission, just acknowledging this conversation and what you've outlined, Judge Rosie, that we're not ending the work of the working group and that it will be an evolving conversation.
Yeah, I think that would be good. And we'll be at the meeting and we can say, you know, the resolution and the work was done before we got the public comment. And so, this is the work we did before. Obviously, we're gonna keep on. I
Yeah,
think
and
that
I
would make
think
sense.
I mean I think it shouldn't be lost on us that the key thing right now is our endorsement and support of the proposal. And it sounds like we've established a great sort of collaborative relationship with the authors anyways. And so these comments will all somehow get to the ongoing work. But I do think it's critical to move quick and be very direct and clear about the support for the proposal.
Okay, well, Efrina's, I'm gonna count that as you moving to adopt the resolution. And so does anyone want to second?
I'll second.
Thank you, Ken.
Okay, and I can call the roll call vote. Alikani,
Yes.
Babcock,
Yes.
Campbell, absent. Escobedo,
Yes.
Morales, absent. Smith,
Yes.
Judge Rossi.
Yes.
Great. 5 yeses, 0 nos, 2 absent. Motion passes.
Excellent. Thank you, everyone, again. So grateful to this committee for how engaged everyone is in the things that we are doing. And this is a new committee and with a new charter, and so just really grateful that everyone is so engaged in giving such thoughtful feedback to all the work. Okay, moving on to item 4.3. Which Jennifer, I think you're also going to present for us.
Yes.
And that has to do with our Legal Aid Justice Technology Collaborative.
Yes, thank you. Let me put this into presentation mode as well. All right. Yes, this is agenda item 4.3 to approve the recommendation regarding the Legal Aid Justice Tech Collaborative Work Plan. We'll go over some background, the work plan's foundational principles, implementation phases, then the deliverables. We'll have time for discussion and we'll review the proposed resolution. All right. So in November 2024, the Office of Access and Inclusion hired a consultant to assess our office, as well as a pilot cohort of 6 grantees who are shown on this slide. The assessment was designed to understand the IOLTA community's operational efficiency, including its use, knowledge, and capacity for legal technology and artificial intelligence, or AI. The consultant completed its assessment and stress tested its recommendations with staff, State Bar leadership, and a larger group of grantees in April. Then at the May 6 PDI committee meeting, staff and the consultant presented the draft recommendations for a statewide legal technology project to support grantees. And this is what we're calling the Legal Aid Justice Tech Collaborative. During the May meeting, the PDI committee formed a working group in order to further evaluate the consultant's draft blueprint. And this working group, the LAJTC working group, met 3 times to review the draft work plan and provide additional recommendations related to project deliverables, guiding principles for the project, and the timeline. The working group consisted of a mix of commissioners from the PDI committee, grantees, both those who were pilot participants as well as others, and academics with expertise at the intersection of legal tech and legal aid. And so this and the next slide name our working group members, and I want to give a big thanks to everyone on the working group for their hard work and commitment to the project. We have 3 commissioners on the working group, Judge Rosie, Jacqueline Alikani, and Vanetta Campbell. And if the commission members have anything to add during the presentation, I would, of course, encourage you to do so. Okay, so foundational principles. Throughout the life of the working group, the members made clear that they felt really strongly that certain principles should undergird the entirety of the LAJTC. As a project of the Commission and the Office of Access and Inclusion, these principles ground the Legal Aid Justice Tech Collaborative Work Plan, guide all recommended project deliverables, and indeed speak to the project's larger philosophy. The first principle is to foreground the ethical use of technology as a tool to advance access to justice. The LAJTC's primary goal, as shown on this slide, is to help grantees understand and safely deploy emerging tech to expand access to justice at scale. The Commission's mission and strategic plan, as well as Goal 5 of the State Bar's strategic plan, make clear the importance of aligning tech with public protection. Legal technology and AI raise important ethical concerns about privacy, confidentiality, bias, and accuracy. The goal of this project is to ensure that grantees' use of tech mitigates, rather than exacerbates, the deeply entrenched social inequalities that already disproportionately impact legal aid clients. This core principle therefore mandates that the project continuously evaluate tech usage in order to ensure alignment with the missions of the Commission, the State Bar, and the legal aid community. The second foundational principle is community ownership. The project's long-term goal is to ensure sustainability through grantee ownership and support. And the third and final foundational principle is supporting grantees across technological maturity levels and financial resources. The LAJTC is not just an AI project for grantees with big budgets. The project will support all grantees across implementation stages and with all size budgets, and recognizes that different types of technology can help legal aid work more efficiently and serve more clients. So now we'll talk a little bit about the project implementation phases. The work plan's 15 deliverables are grouped into 4 implementation phases. First is immediate, and this phase represents the first 6 months of the project, which will end next month in November 2025, followed by the short-term phase, which will cover months 6 through 12, or from November 2025 to May 2026. The intermediate phase will be May 2026 to May 2027, and the final transformational phase will begin after May 2027. The deliverables in the first 2 phases create the foundational framework for the project, whereas the intermediate and transformational phases are geared more toward project sustainability. And now we'll go over the deliverables by implementation phase. This slide shows the deliverables for the immediate phase. So first is investing in centralized strategic leadership. This involves hiring a dedicated staff to spearhead the LAJTC work plan's implementation. This person will be the legal technology lead. And this person has been hired and will be onboarded in mid-November. So with that, I want to briefly introduce Helen Peterson, who will speak a little bit more about this deliverable.
Hi, everybody. I'm Helen Peterson. I lead the Office of Digital Transformation at the State Bar, which is within the Executive Office. I've had the opportunity to stay connected to the LAJTC effort since we engaged the consultant for the assessment last spring, and I'm excited to share that the legal technology lead that we've hired will be embedded within my office while working very closely with Jennifer and OANI. This structure allows us to leverage shared learnings. The State Bar and legal aid organizations are grappling with many of the same questions around AI and technology adoption, so this collaboration creates opportunities to share insights and scale resources effectively. Nice to meet you all.
Thank you, Helen. So next, for the immediate phase is establishing a governance structure. And this is something that the PDI committee did by forming the working group, which created a governance mechanism to help provide oversight for the LAJTC. And the final deliverable for this phase is to continue to support grantees and provide peer learning opportunities, which has also been completed. Staff rolled out a monthly technology and AI in legal aid workshop series to achieve this deliverable. And the workshop has been big success so far. It features each month a different grantee presenting about their tech and AI project, and is an ongoing series. Okay, moving on to short-term phase, there are 4 deliverables for this phase. The first is to develop an AI risk management framework, and this will help ensure alignment between the technology, responsible implementation, and professional obligations. And the second deliverable for this phase is to establish an AI and access to justice maturity model, which will help grantees assess their current state and capacity and develop a plan to advance their organization to further maturity. The third short-term deliverable is to create a resource sharing platform to preserve institutional memory. And this will help protect against the loss of knowledge due to staff turnover and just ensure that we're sharing well between the state bar as well as grantees in terms of both successes and struggles. And the last short-term phase deliverable is to develop a coordinated network of jurisdictions across the United States to incubate and scale tech innovation and resource sharing. So really thinking about the work that the LAJTC has done in California and will do, and thinking about scaling that nationally. Staff have begun to work on this project and will present about it in a month at Stanford's annual AI and Access to Justice Summit. So we will be sure to keep you apprised about this deliverable. There are 5 intermediate phase deliverables. The first is to develop a data collection, evaluation, and benchmarking plan. And this will be important to ensure that the LAJTC makes sound evidence-based decisions. The second is to systematize an evaluation process for external opportunities and engage a key supplier network. This will ensure that the project can help vet tools that satisfy standards for accuracy, privacy and security, cost and workflow alignment, and then create opportunities for things like preferential pricing to keep costs low. The third intermediate phase deliverable is to establish an AI champion community of practice. Staff are really excited about this. We've informally begun work on this, and it'll really help ensure that there's community buy-in to support project sustainability and facilitate collaborative learning. The fourth deliverable in this phase is to develop a training and capacity building framework. And this will build on the Tech and AI workshop series that I discussed previously in order to create training materials and mobilize the champion network to support grantees across maturity levels and learning styles. Finally, the last deliverable in this phase is to develop role-based tech adoption plans for key roles and to address specific needs and pain points for these roles. And finally, there are 3 transformation phase deliverables. The first is to develop a tech-enabled pro bono engagement strategy to create efficiencies and strengthen and maintain these vital programs. The second is to foster simple data sharing and system connections to ensure interoperability between systems and databases. And the third is to establish a long-term governance and sustainability framework. So recall that one of the foundational principles was community ownership. This deliverable marks the transition towards long-term grantee-driven project governance. So just before I open up the discussion, I want to note that this is a rather ambitious work plan, and it will likely continue to shift a bit as technology changes and as the legal tech lead comes in. However, staff believe this work plan lays a really solid foundation for the legal tech lead to hit the ground running when she onboards in a few weeks. And I would now say, if we have time, happy to open up the discussion.
Questions for Jennifer about the work plan? I will note that that, as she indicated, there's already rollout on the webinars, and I believe the next one is next Tuesday. So if folks are interested, I encourage you to sign up. I'm going next week. So please, it's, you know, really a really innovative collaborative program. So if you're interested in learning more about it, feel free to hop on one of these webinars that they are doing, I think every month, right?
Yes, it's
Every month.
monthly.
Yeah. But other questions about this plan, and it really is great. And I think Jacqueline, who's on the working committee with me, along with Annetta, who's not here, for your work on that and your thoughtful consideration of all the issues involved. And there are lots. Okay, well, no one seems to. Oh, yeah, Jacqueline, did you want to?
I raised my real hand.
You raised your real hand. I was thrown off.
Yeah. I'm really impressed with the work that we're doing. Jennifer's doing a great job, and we have a great team of um, diverse stakeholders, and there's always a very robust discussion about the issues. It is, our plan is very ambitious, and I'm excited about I'm excited about the potential because AI is such an important area with a lot of important potential in so many different ways. So I'm looking forward to where we're going and continuing this really important work.
Thanks, Jacqueline. Anybody else have thoughts or comments on the work plan? If not,
Just an
then I will.
appreciation to everyone. Thank you so much. It looks great, and I appreciate you involving the community organizations in the work group. Getting their voices is very important. So thank you all so much.
Yes, agreed. Again, amazing work. Okay, then if no one else has comments, then I would entertain a motion to approve the work plan. And Jennifer's going to put up that there's the resolution right there.
I'll move.
Thank you.
And I will second.
You.
And I will take a roll call vote. Alikani,
Yes.
Babcock,
Yes.
Campbell, absent. Escobedo,
Yes.
Morales, absent. Smith,
Yes.
and Judge Rosie.
Yes.
5 yeses, 0 nos, 2 absent. Motion passes.
Great.
Thank you.
Thank you again, everyone, for being so engaged. Moving on. Sylvia, you are here to talk on item 4.4, the post-election thought partnership. And I apologize. Did we pass you over the last meeting?
No, you
Okay.
didn't.
Okay.
Yeah,
Good.
I appreciate. Thank you for
Okay.
thank you for asking. No, you didn't.
Okay.
Let me see. All right, so good afternoon, everyone. Thank you so much. I'm Sylvia Nam. I'm a senior program analyst in the Office of Access and Inclusion. Today, I'll provide an update on the office's post-election work with grantees. That includes work of the Thought Partnership comprised of Commissioners Ken Babcock, Efrain Escobedo, and Maria Romero Morales. Since May, our office has focused on organizing regular touchpoints with grantees, analyzing emerging trends, and identifying how to best serve as convener and coordinator for the legal aid IELTA community in the state. So as a reminder and as a refresher, anticipating shifts in policy and funding, the office, working closely with the Legal Aid Association of California, launched an engagement series in November 2024. This March, we hosted 2 regional convenings in Los Angeles and San Francisco on the theme Protecting Californians in 2025 and beyond. Morning panels explored innovative service models, while afternoon sessions focused on disaster legal assistance and included small group discussions. We also held facilitated discussion on executive orders featuring public counsel and the Lawyers Committee for Civil Rights to speak to legal uncertainties and to share practical strategies with organizations working within this current environment. These convenings were incredibly well received, and grantees emphasized the value of face-to-face engagement. So following these convenings, the Thought Partnership reviewed grantee feedback with staff and considered next steps. And so if you look in the middle segment on the slide, we decided to focus on regional convenings to highlight areas not covered during those March convenings, particularly rural and inland access. Grantees also asked us to strengthen relationships with non-IOLTA organizations that were mission aligned, specifically the ACLU, to build cross-sector advocacy and to think about what sort of partnerships and opportunities were available on that front. And again, our ongoing goal is to promote collaboration and responsiveness through direct iterative engagement. So as a follow-up to these March events, with LAC as co-sponsor again and input from the Thought Partnership, we planned 3 regionally focused convenings under the theme Resiliency in Crisis. We're midway through the series. So the first convening was held at UC Davis, which centered on rural justice, and you see the image reflecting that. The second was held this week in Los Angeles, addressing immigration, justice, and intersecting issues. And the final convening will be held on November 3rd in San Francisco at our office, focusing on housing justice. Each event foregrounds regional specificity while advancing statewide issues. And commissioners have been able to share opening remarks and to attend panels and serve as panel moderators. So thank you for that work. The convenings have also been an opportunity for the office to share insights from its impact brief titled At a Precipice, How Funding Cuts Threaten Justice for Millions of Californians. It was developed to outline the consequences of deep federal funding cuts to California's legal aid system and the cascading effects on housing, immigrant communities, survivors of violence, as well as the question of rural and inland access. The goal of the impact brief is to inform policymakers, advocates, and stakeholders about the urgent need to sustain and strengthen legal aid as a form of infrastructure and is incredibly important to the social safety net. It was a work product identified early on with the Thought Partnership, who noted the importance that such a brief not just contain quantitative and qualitative data, which are incredibly important, but also stories as important to messaging as well as to lived experience. And so the brief reflects that balance, highlighting leaders in the IOLTA community, highlighting the work of words of leaders in the IOLTA community on what this moment has wrought, along with clients' stories on the value of legal aid in their lives. The brief's other objective is, again, as I noted, to highlight key impact areas, so questions around housing stability, immigration, attorney deserts, and to create a through line with the publication of the 2024 Justice Gap Study. The impact brief also details, also calls attention to the urgent need for policy makers and advocates to reinforce and renew California's legal aid infrastructure. So I'm sharing with you an abstract from the brief with some important top line insights from that brief. And this chart illustrates the scale of federal investment in legal aid. So as you see in the top line, there's approximately $187 million that was expected to flow into California's legal aid organizations, specifically IOLTA grantees this year alone, including approximately $56 million from the Legal Services Corporation and a significant and larger share of funding from federal agencies such as the Department of Justice, the Department of Housing and Urban Development, as well as Health and Human Services. While LSC remains on the federal rescission list, LSC leaders have communicated that they expect funding to remain stable through the continuing resolution. However, with that said, uncertainty itself and cuts elsewhere that grantees are experiencing threaten planning and service continuity. And so the broader claim of the impact brief is to say that investment in legal aid is not only a matter of justice, which it is, but also sound policy, social policy, fiscal policy for the state of California. And so it also cites a study that shows that for every dollar invested in legal aid, there's a return on $7. And in the process, it reduces strain on courts, hospitals, local governments, while strengthening families and communities. And so another way to put it is that civil legal aid has a 700% return on investment. So to share with you some of the findings from that impact brief that we've shared with grantees at the convenings so far and that we'll do in San Francisco is that one, federal funding is foundational. So it comprises roughly a third of California state budget, and this supports education, housing, healthcare, and safety net programs like SNAP. Cuts at this level would hit the most vulnerable first: immigrant families, older adults, veterans, people with disabilities, and those who've been historically marginalized. Two, poverty and inequality are rising again. So with the end of pandemic relief, poverty has returned to pre-COVID levels. And so now over 13 million Californians now live in or near poverty. The highest rates are among seniors and children, and racial disparities are, not surprisingly, but unfortunately persistent and troubling. So 25% of Latinos and 22% of Black Californians live in poverty. Third, legal aid is a critical part of California's safety net. So as we know, everyday crises, whether they be evictions, wage theft, family instability, are legal problems that legal aid helps to resolve. And so the State Bar that funds 114 organizations this year through IOLTA, the Equal Access Fund, and other programs, does so in partnership with these federal sources. So when federal support weakens, the effects are not just immediate, but long-term, impacting both clients who depend on the services, but I think also the impact brief focuses on the organizations and the staff of those organizations that deliver the services. So here's an image from our UC Davis convening on rural access to justice. This discussion emphasized both the challenges and creativities of rural legal aid. One of the panelists noted that if we think about the question around rural justice and rural access, it's actually a historical one based on common misperceptions. Oftentimes we understand rural communities or rural areas filled, I think she said cows, but in fact, the access to justice has been kind of a persistent, pernicious as well as historical problem. And others talked about misperceptions, for example, around Native Americans, with a common belief that Native Americans no longer exist in California. So what it means to really be a service provider with those prevailing misconceptions that circulate. So in this final slide, the impact brief closes with tentative recommendations that I'd like to share with the committee that focus on protecting, again, access to justice that strengthens California's legal aid infrastructure. So the first is to scale up state funding to legal aid. And so this would call for an increase to the Equal Access Fund by at least $40 million to offset federal losses and stabilize reserves. The thinking behind that is to prioritize multi-year, again, aligned with existing IOLTA allocations, to prioritize multi-year flexible funding to prevent homelessness, maintain family stability, and resolve urgent legal needs. The second one is to restore flexibility to address emerging issues. So thank you, Commissioner Babcock, for helping the staff work through this. So this would be eliminating restrictions on EAF requirements that divert precious staff time from urgent service delivery, which then diverts forces staff to do administrative oversight, basically additional burdens when it comes to intake rather than providing services. And so by eliminating these restrictions, it would align EAF with IOLTA's flexibility to support operations as well as services. And the thinking there is that greater flexibility enables a much more immediate response and maximizes community impact. The third is to promote cross-sector and state collaboration. So this would be to expand collaborative models that work, as we know, such as medical legal partnerships and housing first legal models that really integrate legal aid into health and social systems. And this also builds on the work that the office does around interagency collaboration. So to establish formal state agency partnerships and working groups to identify needs and embed legal insights into program design. The thinking there is that collaboration improves outcomes and strengthens cost-effective service delivery. 4, 5, 6 has some overlap, but I'll name some of the distinctions. So the fourth is to provide, to build public-private partnerships, and the thinking there is to partner with private philanthropy and the private sector to test innovative or potentially higher risk models. So this state funds could be used to sustain proven programs launched through private investment. And there we could frame legal aid as part of broader strategies to reduce poverty and strengthen economic stability and improve mobility. The fifth is to create and strengthen organizational resilience and workforce capacity. And so this would be focused on helping legal aid organizations weather funding cuts and transitions, to support things like strategic planning and reorganizations that preserve service continuity, as well as to expand fellowships and loan repayment programs to recruit and retain a skilled, diverse workforce, especially in rural areas. And the last is to build an immigration legal capacity. And so this would be to establish a statewide immigration legal fund to expand representation and protect mixed status families. Like the other proposals, it would be to support, the thinking here would be to support multi-year flexible grants for things like attorney recruitment, rapid response networks, and family preparedness services. And so the goal would be to strengthen partnerships between legal and social service providers to strengthen as well as to safeguard immigrant communities. So to close, this post-election work reflects the ongoing commitment on part of the committee, the thought partnership, and the commission to coordination and strategic responsiveness to the IELTS community. Happy to take
Thanks, Sylvia. Yeah.
reactions, responses.
Yeah, reactions, responses. If anyone has them, I just want to thank the commissioners who are on this this call, who I know have either served on panels, served as made opening remarks at convenings, and worked on this with Sylvia. I appreciate your participation in this. It takes all of us, and I know many of you on this call have actually already participated in. I'm going to participate in the one on November 3rd. So really appreciate your help. Ken, and then Efreen, and then Celine.
So I just want to thank Sylvia for her very thorough and thoughtful presentation, as well as all her work on the issue brief. And thank her and other State Bar staff for all the hard work of pulling the 2 convenings that have already been held and the one that's coming up on November 3rd. Those are not easy things to get people together. And so just thank you for all of that effort. Sylvia, any insights that have come out? You talked a little, you showed the image from the convening in Davis. I know the convening in Los Angeles was just this last week. Any insights preliminary thoughts as to, anything that came out of that convening that might be important for us to know?
Thank you. So we're in the process of really kind of collating all the insights that grantees shared with us and to kind of think through what our priorities are. So at the Davis convening, it was smaller and more intimate because it was focusing on questions, because rural service providers, I think, constitute a smaller number of organizations. And I didn't say that some of the focus of the convenings included a tabletop exercise on disaster legal services, as well as, again, a regionally focused panel. And then for LA and San Francisco, facilitate a conversation with the ACLU. I think grantees are thinking about contingency and have asked for feedback on what that looks like. what it means to operate under conditions of incredible constraint at an organizational level, but also with part of the constraints being increased demand for services. And so there were a few suggestions from the LA convening, and like I said, we're collating the responses from grantees. I think the other thing that I noticed is that grantees have been talking about just the incredible difficulties with funding cuts, the need to pivot quickly, and it's an issue facing small organizations as well as larger ones. And so I think we're thinking about what contingency will be, and the State Bar can't advise organizations what to do, but I do think about alongside LAC how to create some sort of resources for organizations in response to the convening.
Thanks.
Ephraim.
Thanks, Judge. Want to echo Ken's congratulations, and I had a chance to participate and provide opening remarks at the Los Angeles convening, and I just wanted to share a couple of quick reflections. One is to further commend staff. We all go to a lot of these convenings. We make a living out of bringing people together and convening. Just amazing execution. This was not a state staff just talking at organizations. It was truly just well planned out program. It was a really great space. So just wanted to thank them for a quality convening. And then second, just wanted to highlight how important these are, and that we should really look at the success of these and think about how they are part of our work throughout, for a couple of reasons. One is there were some amazing insights from grantees. Second is there's obviously a great deal of trust on the part of organizations with our staff at the bar. And so that is something that should be an advantage and fully leveraged. The conversations were deep, honest, very reflective, and I think we should leverage that trust more. They've done a great job of building it. So just wanted to say, really enjoyed participating in it, but it was very evident that this is a very powerful way for us to think about how to make our work more impactful and how to lead in doing this in a more collaborative approach versus a funder grantee approach.
Thank you.
I just have like more context for all, and I realize it's the end of the meeting and it's a Friday afternoon, so I will be quick. A lot of your grantees are talking very seriously about merging, about layoffs. And this is coming up in these meetings, not only on the panels, but also kind of in the hallway conversations. And like, it is really, really rough for programs now. And I know that Sylvia talked about federal funding cuts to legal services, but what's hurting organizations a lot right now is that when there are federal funding cuts to the state or federal funding cuts to the city or county that cut other services, one of the ways the cities and counties will be able to try to bridge the gap is by cutting their local grants. So we are really worried about a lot of cuts that are the bad collateral consequences of federal funding cuts, just generally throughout the state. So I appreciate these convenings. I'm glad that we're doing them because it's encouraging people to really talk a lot about planning now, but they are not easy conversations.
Yeah, thanks. Yeah. Luana,
I
yes.
was just going to add, obviously we're focused on California, but we've been kind of trying to map out also what's happening nationally. Last week, Sylvia and I were at the ABA IOLTA conference, and we're part of the network of IOLTA funded states that have IOLTA programs, and they're just like really reeling right now. I mean, there are 5 states, and I'll do a more full report at the commission level, that have had their IOLTA funding at threat. I mean, one of them, North Carolina, completely has had their IOLTA funding froze. New York, the legislature came in and took $100 million. So, when we talk about California, yes, things are very bad, but Sylvia and I were like, look at the states. I mean, it's like it's a little bit of a privilege to be in California and be able to have these conversations, even a public meeting like this, and be able to say this out loud. But it's I mean, I know the theme of the day has been how difficult it is. Like, we can't underscore. I mean, Selena moderated the contingency panel in Davis and Elizabeth did in LA. And it's just things that, you know, but when you hear it from an ED talking about layoffs and how they're communicating that to their staff and how they're trying to stay strong, it's a very difficult time.
Thanks, Dawn. Yeah, I frequently think how glad I am to be here. Okay, any other comments on this excellent work? Okay, seeing none, and we don't need a vote on anything, so we can move to Danielle and an update on the Cypre funding.
Yes, and I will be quite brief. I think I have 3 slides total, 4 slides with the title slide. So we'll be quick. So we gave a brief update regarding Cypre funding and our efforts in this space at the last meeting in August, but wanted to come back and give you yet another quick status update. So as a reminder, and also last time we didn't have slides, so I verbally said some of this, but put it in front of you in writing if that's helpful. Cypre is a longstanding legal document that essentially directs unclaimed class action settlement funds for class members that can't be identified or contacted or don't cash their checks when they are sent one, and so forth. Those remaining settlement funds can be directed to nonprofits that most closely advance the interests of the class or the purpose of the litigation. And there is not state bar, there is state law, state policy that through California Code of Civil Procedure, Section 384, that says it is state policy to ensure Cypre funds are distributed to further the purposes of the class action or cause. And one of the explicitly listed options there is to promote justice for all Californians. And so the State Bar's Justice Gap Fund has long been considered a qualifying Cypre designee. And in the last couple years, we have received about $7 million, a little over $7 million in donations to the Justice Gap Fund through Cypre designations. Those funds then get administered to IOLTA EAF grantees. Historically, it has been through the IOLTA grant distribution by formula. And so we, and when I say we, this is the State Bar, Legal Services Trust Fund Commission, also working with LAC and California Access to Justice Commission, are talking about ways to increase Cypre donations to legal aid. So that's to legal aid nonprofits across the state, but then also to that Justice Gap Fund. And some of the things we are talking about and working on are updating the State Bar Cypre declarations to provide more information on the impact of legal aid, what those funds actually do when they make donations to the Justice Gap Fund, and then also how those funds may be administered. So I mentioned that they have historically been administered via IOLTA formula. That's not a requirement. And so the State Bar and the Commission have demonstrated interest in using those more flexibly. And so we've updated our Cypre declarations to say that they may be used to address urgent and emerging needs in the community, for example. We're also discussing with LAC and California Access to Justice Commission possible policy changes to increase compliance with that California Code of Civil Procedure. Again, that states donations to legal aid and advancing access to justice is a wildly appropriate use of Cypre funds, and also updates to settlement approval checklists potentially in the counties where class action litigation is most often filed. So it's right in front of judges of like, hey, is there a plan for residual funds in this case? And if so, putting that language back in front of them in some way, pointing to access to justice and legal aid. And then also we are working on updating a Cypre toolkit that was last created in 2015, and additional educational materials for complex litigation judges, class action attorneys, and legal aid more generally on how and why to dedicate and designate Cypre funds to legal aid. Last slide here is just to talk very briefly about that possible discretionary grant program. So as I mentioned, State Bar and the Commission has signaled interest in creating a flexible discretionary grant program to administer those cypre donations. And we actually held a grantee focus group related to the justice gap more generally earlier this week, and it included gathering some initial feedback on this idea. Grantees, frankly, were a little bit mixed. Some were really excited about this, and some weren't convinced that it was for them. Some hesitation, frankly, just about like applying to yet another stream of funding. But they had a lot of really good questions about, wanting more information on what this grant program would look like. Is it something like a fund that is available and then just gets depleted over time? Is it like an RFP process where we cyclically open an RFP opportunity, but then once it's closed for that cycle? And then had some questions about what would be considered urgent and emerging issues. All very good questions. Because this is very much in the exploratory stage, we did not have answers to those questions and did not expect to have answers to those questions because those questions would be answered by this committee, the commission, throughout building out what this program would look like with a lot of community engagement through LAC and Access Commission and so forth. So yeah, that is the end of my slides. I will stop sharing those so we can chat about any feedback or questions you all have.
Thanks. And thank you, Selena. I know you're working on the toolkit update, so thank you for that. Yes.
Well,
And now I'm going to call on you.
This is not about the toolkit, it's actually about the listening sessions, because what I've seen over the past couple of months is that a lot of the grantees were kind of neutral on the idea of making more discretionary grants available. They, pulling away from the formula grants. They're like, oh, well, if I can apply for it, if it could be used for bridge grants. But because of all the funding cuts, people are getting a lot more nervous. And I've definitely seen a shift in their opinion where cypre still feels like it is a windfall. You can't plan for it. It's not really taking away from formula grants, but they are less supportive of carving out some formula grants for these urgent and emerging needs where this is not the conversation we were having last year. So.
Yeah, and I'll just say that mirrors the conversation we had on Wednesday. It was a really small group, admittedly. I think we had 6 grantees represented, and it was small by nature, but so it was not representative of the whole community, I don't think, but that was a tone shift that we noticed too.
Erin and then Ken.
Thank you for this. I think it's great. And just a really brief comment actually goes to what you just mentioned, Danielle, that you had about 6 people at that focus group. We've heard a lot about how stretched people are right now. And frankly, like, I don't want to say panicking, but I mean, it's a tough time. It's really hard for people to make time in their schedule to go to meetings. So I would just encourage us going forward to think about other ways to get feedback along the way. I love that you're getting the feedback. It sounds like they had a lot of feedback and great questions, as you pointed out. And just thinking about alternate ways to get feedback instead of those focus groups, I think would be great because people, I know when I was in ED, my schedule was booked out 3-4 weeks. So if you schedule something in 2 weeks, I can't be there. Yeah, it's just hard for people to do that. And also to, speak freely and have enough time to absorb the information and give meaningful comments all in the same hour can be challenging. So
Erin, do you have a suggestion? Like what's another mechanism that is
I mean, like written comment, just over a period of time that can be, worked into their schedule.
like a survey? Because we thought about a survey and then we dumped the survey idea because it
Yeah, I don't
didn't
know,
feel
but
like that
everyone
was
had survey fatigue.
yeah.
I mean, even just like sharing like the slide deck. And I don't want to create more work for you all either, like having to write up something really formal and, that people can respond to and write. But even just sharing the slides and saying, give, 4 weeks to just give any written comment as well. And like a meaningful amount of time too, like a week or 2, frankly, it seems like a lot, but it's not. I mean, it just goes like that and everyone is so busy. So.
We created slides for the focus group, and I think we wouldn't necessarily share them in that form, but Dawn, if we wanted to go down that road, I think there's like a starting, material that we could work
Yeah,
from.
I mean, we could think about it. For this one, we did want a conversation to explain through because I think at advice of Selena, that there was a little bit of concern and like maybe suspicion even because we were doing more as exploratory and plus we had a statutory requirement in order to get some feedback. So we're using the statutory requirement as an opportunity for us to reach out, but it was a really just a light touch point. We were yeah, so I mean it's a balancing act, but I do hear you.
It's a both.
Yeah.
I mean, you got 6 people out of 120 organizations, so
Yeah,
tells you.
we capped it at I think 10. Like we wanted it to be a really small group. And then we had some last minute cancellation. So I think there were 6 or 7 folks that were there. But yeah, I take your point, certainly.
Thank you.
Ken.
And just to be clear, this educational effort and the toolkit is not just focused on trying to drive Cypre donations to the Justice Gap Fund. I think historically, more money has gone by way of Cypre directly to legal services programs than has gone to the Justice Gap Fund. And part of what this educational campaign and toolkit is all about is encouraging parties and judges to direct Cypre monies to nonprofits as opposed to simply letting it revert to the general fund. And that is what we heard is happening in a growing number of cases. And given the limits on the state's ability to use that money, having to hold on to it for a period of time, it seemed to all of us involved in this conversation that was a particularly, given the issues we're all faced with right now, a particularly bad way to go to direct this money to just sit and do nothing for several years rather than have it be put to use right now, be it by legal services organizations or other nonprofit organizations.
Yeah, that's exactly right.
Yep. Thanks, Ken. Okay, any other comments? All right, seeing none, we don't need a vote on any of this. That, my friends, takes us to the end of our agenda for today. Unless I am forgetting something and Danielle would tell me if I was.
You are not.
Okay, again, I want to just thank the commissioners. I know Aaron had to drop off already, but thank you all for being so engaged. Thank you, Lauren and Selena, for being here as well, and for all the help that you provide the Trust Fund Commission and the State Bar. But really just super grateful to this committee for just how engaged everyone is and how hard everyone works, both to be at these meetings, but also in all the working group meetings. So thank you again. And I look forward to seeing you all in a couple weeks at the Trust Fund Commission meeting. Thank you. And with that, we are adjourned.
Thank you all.
Have a nice
Thanks,
weekend,
everybody.
everyone. Thank you.